Welcome, everybody. I can see that we have a good number of attendees that are here with us. I can see the numbers increasing slowly, so I'll just start with some brief welcome remarks. I'm Kiran Sangera, Special Counsel at HKIAC. And on behalf of HKIAC, I'm delighted to be collaborating here with MIAC, the Madrid International Arbitration Center, on our first webinar together. And this is in fact great, as it's put into practice very quickly the collaboration agreement that MIAC and HKIAC entered into recently. The topic for today is also very appropriate given the institutions involved. We'll be looking at commerce, trade and dispute resolution between Asia, Spain and Latin America. And we'll be focusing on recent developments, in particular in Hong Kong and China, and also in Spain. So just again to say it's an absolute pleasure to be working with MIAC and look forward to many more collaborations in the future. I'll hand over to Damaso Riaño, who is representing MIAC today. And it's again a pleasure to be sharing a panel with him. Damaso.
Thank you very much, Kiran. I wanted to say many thanks to the participants for making time to attend this joint event, and many thanks also to the Hong Kong International Arbitration Center, and particularly to you, Kiran, to Chloe Huang, and to Victor Gamero for organizing the event and for giving MIAC the opportunity to explain recent and relevant updates concerning arbitration in Spain. As you may know already, MIAC is the result of the merger of the international activity of the Madrid Court of Arbitration, where I work, the Civil and Commercial Court of Arbitration, and the Spanish Court of Arbitration. Those are Spain's three major arbitral institutions, which have been joined in the project by the Madrid Bar Association as a strategic partner. Through MIAC, these four institutions combine their experience of over 30 years administering arbitrations, their efforts and the resources in order to provide users with an independent, transparent and efficient international dispute resolution service. MIAC only administers international cases in Spanish, English, Portuguese and French, and those derived from either one, arbitration agreements designating MIAC as an administering institution, and two, arbitration agreements designating any of the four promoting entities as administering institution, provided that they are signed after 1st of January 2020. MIAC is the first genuinely international arbitration center based in Madrid, and it has been an aspiration of the Spanish-speaking arbitral community for years, and we are very happy to see that functioning at last. It has been now 1 year since MIAC was launched, and the center is already handling its first cases. And if any of you are curious, please feel free to contact me or check the center's webpage, madridarb.com. Let me also say that we're very happy to partner with leading institutions like the Hong Kong International Arbitration Center in the promotion of arbitration, and also with leading practitioners such as Claudia Benavides from global firms like Baker McKenzie. She will be moderating today's session, and I will say a word about her because rather unfairly, moderators are not always properly introduced. Claudia is a partner at Baker McKenzie. Since 2010, she heads the dispute resolution practice in Colombia, and in 2018, she was appointed chair of the Latin American dispute resolution practice. Since 2019, Claudia is the global chair of the firm's dispute resolution group. She is a listed arbitrator of the panel of arbitrators of the Center of the Chamber of Commerce of Bogota for both domestic and international arbitrations. She's a listed arbitrator of the panel of arbitrators of the Shanghai International Economic and Trade Arbitration Commission, and a listed arbitrator of the panel of the Arbitration Court in AmCham, Peru. Claudia is highly regarded as an expert in transnational litigation and arbitration. She has over 20 years of experience handling complex cases related to a variety of topics: construction, infrastructure, post-acquisition, energy, distribution and supply, among others. So a long story short, we are in good hands. So Claudia, thank you very much for moderating this conversation, and the floor is yours.
Thank you, Damaso. Thank you, Kiran. It's a great pleasure to be here today. Hello, everyone. Thank you very much for joining us. So many thanks to the Hong Kong International Arbitration Center. Many thanks to the Madrid International Arbitration Center for putting this event together. Today, we're going to talk about recent developments in dispute resolution in Asia, Spain, Latin America. The three key discussion topics that we're going to refer to are the first one, trends in international commerce and arbitration between Asia, Spain, and Latin America. The second main topic that we're going to focus on today is going to cover recent developments in Asia, particularly related to interim measures and the enforcement of awards involving Chinese parties. And then third, as was mentioned before, we're going to focus on a very relevant recent Spanish constitutional court ruling that deals with the limits to public order. To discuss these very interesting and relevant topics, we have today a stellar panel of speakers. Let me introduce briefly the three of them. First, we have Omar Puertas, who is a partner at Cuatro Casas. Omar has extensive experience in international arbitration. And in 2007, Omar moved to Shanghai to set up and manage the firm's first office in Asia, where he built and consolidated a sound practice in inbound and outbound investment, as well as in dispute resolution, involving Asian, European, and Latin American parties. We're having with us today, and you've already heard her, Kiran Sanghera, who is the special counsel to the Hong Kong International Arbitration Center. She leads the domain name dispute resolution team, oversees HKIAC's business development activities, and speaks and writes on dispute resolution frequently. Kiran has previously worked at HKIAC as counsel, handling the administration of commercial arbitrations involving parties from Asia, Europe, and the Americas. Kiran has also worked as Director of Litigation Funding at Harbor Litigation Funding, where she was responsible for developing the third-party funding market across Asia. And then we also have with us today Damaso, who, as he just mentioned, he's the Secretary General of the Madrid Court of Arbitration since 2018. Prior to joining the court, Damaso was a partner at Arias Abogados. Damaso specializes in litigation and arbitration and has acted as arbitrator, counsel, and administrative secretary in over 30 arbitrations in jurisdictions across Europe, America, and Africa. Damaso has also practiced extensively in the fields of corporate governance and company law. So as you can see, we do have a panel of experts across many regions. Basically, they know very relevant information across the most important places where many of you probably do business or where many of you practice law. So this is going to be very interesting as we're going to cover these recent developments that are relevant for international commerce and for doing business. So we're going to start today with Omar, who's going to walk us through the trends in international commerce and arbitration between Asia, Spain, and Latin America. So Omar, the floor is yours.
Thank you very much, Claudia, for the introduction and for moderating the session. Thanks a lot to the Hong Kong International Arbitration Center and to the Madrid International Arbitration Center for organizing and for giving me the opportunity to be with you today. So I'm going to start with, we thought it would be fitting to start sharing with you hard data. Hard data. Can you see the screen? Yeah, okay. Some hard data on trends in international commerce, trade, in relation to Asia, Spain, and Latin America. As Claudia rightly pointed out, we speak about Latin America as one thing, and it's obviously not one thing, right? I mean, it's incredibly diverse, and what we are trying to achieve here is really to get a glimpse on the trends rather than a very specific look into each specific country and how diverse they are, really, because they are, but really trying to understand where we are going overall and learn from that if we can actually try to understand where we are going in the future as well. And from that, see the importance of having dispute resolution centers such as the Hong Kong Arbitration Center and the Madrid International Arbitration Center, and how these centers can help us to solve in an efficient way disputes should they arise. In terms of trade statistics, I will start with Spain. As you can see, this is the exports from China and imports to China. It's not a surprise that for any Spaniards, at least, that China exports a lot more than it imports from Spain. The good thing perhaps would be that we are exporting a bit more than we used to, and we import a bit less than we used to. However, the difference is still huge. If we look into Latin America, actually, China imports more from Latin America than it exports, and we will see why is that. That is an interesting trend. If you look into now the 6 major trading partners of China in Latin America, you will see that in terms of what China to where China is exporting, the first partner would be Mexico, the second one would be Brazil. That's again not a surprise given the size of the economies, I would say. In terms of imports, Brazil is way more important, it seems, for China than any other country, and that is most probably due to one single product, soya beans. So that is the answer to this outsized amount of imports from Brazil into China. In terms of what China exports, now we're looking at Spain, Brazil, Chile, and Argentina. Seems the trends are quite similar. If you look into that, is a lot of electronics, a lot of textile, and a bit less chemicals. However, chemicals are incredibly important as well. This is what China exports. What China imports is a bit more different. The case of Spain, at least for 2020, this has changed for the last few years, but there is a lot of meat. This is related to exports of pork meat related products from Spain, and this is due to a shortage at the moment in mainland China, as you all know. Then we have chemicals and mineral products. In Argentina, we have a lot of meat, not a surprise there, as well as oil seeds, medical plants, and so on. Brazil, a lot of mineral products, as you can tell, and very similarly in the case of Chile. This is for trade. How about investments? Chinese ODI means outbound direct investment. So we will look into M&A, mergers and acquisitions, what Chinese are investing in terms of buying, purchasing companies, joint ventures, and greenfield investments. Okay. The overall trend worldwide, the overall trend for China is the first graph up there. So you will see the outbound investment has been going down in recent years. However, not very significantly, I would say. This is still very relevant and will continue to be relevant. In the case of Latin America, again, it reached a peak in 2016, the same as the overall trend worldwide, and it has been coming down. However, this particular data is a bit misleading, and we will see that and why in the following slide. And in the case of Spain, again, it has been going on the decrease lately, and that is not, again, a surprise given the let's say, the size of the economy. Any investment will make a difference of any size, basically, and will change the data in a significant way. Look into now where China in the overall is investing. If we break it down by countries, actually looks like it is going to increase if we break it down by countries, and it's changing the landscape of the investment. So in Brazil, it's going up. In Chile, it's going up. In Argentina, it's going up, the same as in Peru. But it's going down big time in Venezuela. Venezuela used to be the major trading partner, investment destination for China, and it's no longer that. It actually represents almost nothing in terms of investment. We shall see that a bit in other slides in more detail. If we look into now specifically in greenfield direct investment in the last 9 years, again, not a surprise for those of us who engage in business with China and other regions, particularly Latin America, but it's still interesting to realize how consistent Chinese investments are in greenfield investments in Latin America over the years. There is always infrastructure. Infrastructure is the major type of investment. It continues to be extraction and processing of minerals still, and manufacturing to some extent. This is a completely different landscape from other parts or regions in the world. In terms of mergers and acquisitions, this is investments into purchasing local companies, into doing joint ventures, in developing through equity projects together. Again, there is a huge emphasis in infrastructure. Look at 2017, 2015. This has changed from 2011, where there was a clear trend in extraction and processing through mergers and acquisitions. The extraction and processing continues to be the case. However, as we have seen here, they do it by themselves, if you like, through greenfield investments. And in terms of mergers, they clearly focus on one thing and one thing only. Look at 2020 is infrastructure and infrastructure and infrastructure. You know? Project contracting, and with that, I will complete this part of the presentation. We have data as well for project contracting, that is EPC contracts, turnkey projects, renewable energy projects. So what is the overall trend for China international project contracting? It is very steady. If you look at the overall trend graph, has kept basically the same for the last 4 years. While in Spain, it has come up, and the increase in Latin America is very significant in the last at least 3 years, and is representing more and more of their projects outside of mainland China. If we now break it down again by country, then you will see what I meant before. Look at how the newly signed projects have changed in just 3 years, the destination of the projects. While Ecuador used to attract, at the very least in 2018, some projects, it seems on the decrease. Bolivia clearly is no longer a preferred destination, apparently. In case of Venezuela, clearly we have a trend there. Peru is the opposite trend, is more interesting for Chinese, for developing infrastructure, newly signed projects. Argentina, I would say, is a slight decrease, perhaps not too significant in my experience. Mexico used to be basically didn't attract a lot of projects from China. And we're happy to see that this is changing. And Brazil, the largest country in Latin America by far, still attracts relatively not huge amounts of project contracting, if you like, but we see that as increasing. And Colombia is clearly the king of attracting investments in projects from China. You see that trend. So what is changing in just a few years? Look at the trends in Bolivia and Venezuela. So what has changed is that China, while it used to invest or develop projects in jurisdictions that, let's say, didn't have the best relationship with the US, and therefore they were a bit closer to China as a result, that is changing. What it means from my personal view, my personal reading of this and experience is that China feels more and more comfortable doing business, not from state to state, but rather from business to business. And that translates as well into the type of disputes that, at least in our firm, we are seeing. We see, and I'm happy to see that the statistics of several arbitration institutions seem to confirm this. We see in the case of Chinese companies becoming less and less shy in participating in international arbitration cases. So we see that as a very important trend. Significantly, I must say, at least in commercial arbitration cases. So at the moment, I believe that according to the ICC, Chinese parties represent, they are the 5th most represented nationality in international arbitration commercial cases. This is a major change that was not the case just 5 years ago at all. And overall, Asian companies are becoming more and more involved in international arbitration disputes. They are more willing to play by the book, if you like, of commercial disputes. They do not rely so much on states. They rely more on the actual tools that we have to resolve commercial disputes. And this is to me a huge change. I remember back in the days in Shanghai or in Beijing, meeting state-owned companies and in regards their business in Latin America, and they would tell me clearly they were not worried about disputes. To my dismay, of course, not that I want them to have disputes, but you can imagine when the client tells you, I don't care about disputes. Why? Because I belong to the Chinese government. Nobody is going to sue me, Omar. So do not care about the dispute resolution clause. Care about the other matters or clauses in the contract. This has completely changed. What is not changing is Chinese companies resorting, at least not in my experience, resorting to investment arbitration. They are not resorting to that. As far as I know, prior to 2010, only one Chinese company initiated an investment arbitration case. And since then, only six. Compared to any other nation, this is basically nothing. So it is still Chinese companies. And however, China has the second largest network of bilateral investment treaties in the world, second to Germany. So even that being the case, they are not using the bilateral investment treaties that they could resort to. And with that, that is basically my time. I finished my part of the presentation. Thank you very much.
Thank you, Omar. That was all very interesting. And I have to say that the information that you provided, just with respect to Colombia, it really resonated with what we've seen here. As you probably know, one of our major projects is the metro in Bogota, right? The subway. And it was a Chinese consortium, the one that won the bid, right, for to contract the design and construction and operation of the first line of the metro here. So it's the major, biggest project that we have. And then we've also had Chinese other project contracting through Chinese companies in our country. And the trend that you mentioned with respect to dispute resolution, we actually saw it here with a Chinese company that was actually the EPC contractor for a power plant. And when the dispute arose as a result of delays in the project, then they resorted to arbitration. The matter and the dispute was resolved through international commercial arbitration. It was actually a very relevant case here because so the case in itself dealt with many interesting international arbitration issues that had not been decided before by tribunals in Colombia. We have a international arbitration law that is fairly recent. It was enacted back in 2012. So as you can imagine, it has been evolving through time, but there are many things still to be interpreted. And in that particular case, very relevant issues were decided. And then, of course, the losing party resorted to annulment. And that was also the very first time that very relevant issues, again, to interpret the international arbitration law were decided. And then the point here is that Chinese companies were following all these procedures and they were acting just as any other company would have done, resorting to this mechanism. So totally aligned with the trend that you just described. I think that now we're going to switch to Kiran. There are a couple of recent developments in China that are very relevant for international arbitration and therefore for businesses, right, that resort to this mechanism as a way to protect their interests. So Kiran is now to walk us through interim measures and enforcement of award involving Chinese parties. So over to you, Kiran.
Great, thank you. Omar, that was, as always, supremely interesting. We don't often at dispute resolution or arbitration events hear about trends in terms of transactions and where the activity is happening. And actually we should, because it will always trickle down to the work that we see at the institution. And just your comments there about PRC parties. I mean, I've been at HKIC since 2011, and even the change of participation of PRC parties in our caseload in that decade has been interesting. So in terms of participation, the participation level has increased significantly. And people must keep in mind for HKIC, we will see year in, year out, about 40% to 50% of our caseload involve PRC parties, usually against a non-PRC party. So we have a good point of reference there. And, you know, previously you could say that oftentimes the PRC party may have been the respondent, may not have participated, although there are many jurisdictions where that does happen. But what I can say is over the years, that's dramatically changed. In terms of the PRC parties as claimant, that's extremely common, and if it's not 50-50 these days, and the level of participation in the process and the tools that are being used, and the lawyers within China who are extremely sophisticated in arbitration, who are fully engaging with the process. So there's certainly been a big shift in the level of participation of PRC parties in our caseload too. And also just to keep in mind in terms of SOEs, you mentioned those, about 10% or so of the cases that we have that involve PRC parties are SOEs. And again, the trends are the same, full increasing engagement, you know, and efforts to resolve the dispute, whether that be on the claimant or the PRC side. So of course, there are always recalcitrant or non-participating parties, but if we're looking at trends, there's definitely been increased engagement. And it's interesting, the jurisdictions that you mentioned, I'll get onto my presentation in a second, but I might make it much shorter after what you've said, because that's so interesting. But yeah, I mean, a lot of those countries we've seen involved in our caseload. So Brazil, one would expect, Panama, quite a lot. But that might be because they were entering into more transactions a while back, and now we've seen those disputes over the last 5 years. Mexico, Peru, and of course Spain. So yeah, all very relevant. But Colombia, it seems to be the interesting spot. So not look forward to, maybe Claudia does, but some disputes coming out of that jurisdiction in relation to PRC investment. But what I'll do, and hopefully it remains very relevant. I know some of our Asia attendees may have heard a few of these points before, although there are some new aspects. But certainly those from Europe and further afield, the two developments that I'll talk about, hopefully will be quite new and interesting to you. They really do relate to discussions just about China and its involvement. And in fact, if you're doing deals with PRC parties, you do need to keep in mind, or Chinese elements, whether there are assets on the mainland, you do need to keep in mind how you can ultimately recover. And part of that is focusing on preserving assets as well as being able to ultimately recover those through effective enforcement of an award. So in essence, that's those are the two areas I'll focus on. Next slide, please. So two key arrangements, that are, one is recent, the first one, the arrangement on court-ordered interim measures in aid of arbitrations between Hong Kong and the Supreme People's Court in mainland China. So this is an arrangement that was entered into in October 2019. And as the name suggests, it relates to interim measures to support arbitral proceedings in both Hong Kong and mainland China. And I'll tell you why that's interesting and unique in a moment. But that relates to prior to the arbitration commencing and during the arbitration. And then the second arrangement is one that's been in force for quite some time, but there have been some amendments to it that were introduced in November last year. And that relates to the mutual recognition and enforcement of arbitral awards between Hong Kong and mainland China. So both arrangements really focusing in on Hong Kong and PRC and the legal instruments that have been entered into. So next slide, please. So the first one, this is the game changer one, and I can feel that some of our HK and PRC attendees might be rolling their eyes because it's something that we talked about a lot. But there are some developments here, and it is pretty important that users know about it, whether they're in the region or further afield, if they're doing business and assets, you know, and there's elements that involve China. So what is it? It's a legal instrument between Hong Kong and mainland China, and it relates to effectively where it's really important, I would say, is in relation to Hong Kong seated arbitrations in which you can now seek interim relief from mainland courts. Important point here, it's the first time mainland China has entered into an agreement to allow its courts to issue interim relief in support of arbitrations outside of mainland China. That was not possible before, save for certain maritime cases. And Hong Kong's a place where you can do that. As I said, this relates to Hong Kong seated arbitrations administered by 6 qualifying institutions. And I suppose I wouldn't necessarily be talking about it unless HKIC was one of those 6 administering institutions. But this really is a game changer. So what can you apply for? What sort of orders can you apply for to mainland courts that you couldn't do before? So preservation of assets, evidence, and conduct. Where can you apply? So your arbitration seated here, it's an HKC arbitration. You can apply to mainland China to the intermediate people's courts, either at the place where the respondent is resident, or alternatively, the place where the assets or evidence is located. You can apply through the institution, which is common practice in mainland China, but common practice in Hong Kong is that parties would apply directly to the courts, and this arrangement takes that into account. So parties can apply directly to the relevant mainland courts. When can you apply? Well, you can apply once the arbitration is commenced, but before the final award is rendered. But you can also apply before the arbitration has been commenced, provided you file your arbitration within 30 days of an order being issued by the PRC court. If you don't, then the order that's been issued will be terminated. Next slide, please. So a bit about the practice. Fairly, I suppose we could say fairly straightforward from the HKC's perspective, but importantly, what an institution is required to do is to prepare a letter of acceptance of the arbitration. And this is a key document that the parties must then include in their application to the relevant PRC court. Other documents that need to be included in the application is the application itself for the measure that you want, the arbitration agreement, identity documents, the notice of arbitration if you've already commenced it, and then in order to get the letter of acceptance from HKIC, we need to see a copy of the application for interim relief and any supporting documents. There's no fee for this. It must be in Chinese, so we prepare the letter in Chinese, and we will usually do that within 24 hours. We can either deliver that letter directly to the court or back to the applicant so that the applicant can make the complete application together. I think what's helpful for some of the people here, these documents are in Chinese. So what we have now on our website is a section where the documents have been translated, including the templates. So parties can go there and see what the process looks like if they're not fluent and able to read documents in Chinese. Next slide, please. Okay, so we often hear about legal instruments in theory, but what's happening in practice? A lot is the short answer. So as I said, this arrangement came into force in October 2019. And since then, not that long ago, HKC has processed 40 applications, the majority of which were in relation to the preservation of assets, 2 for evidence and 1 for conduct. The amounts we're talking about are not small. So those 37 applications for preservation of assets are worth $1.9 billion US. And I think very importantly, the Chinese courts are engaging with this instrument. So of that amount, the courts have ordered $1.6 billion US worth of assets. So this is not something that academics can talk about and practitioners won't use. It's happening and it's being applied in practice. It doesn't just benefit, well, I suppose it benefits mainland and non-mainland parties. So the applicants, 30% of them are mainland Chinese entities, and 70% are foreign. And in terms of the assets to which, or evidence or conduct to which the applications relate, 60% approximately are in relation to mainland Chinese assets, evidence or conduct, and the rest are foreign or jointly owned, relating to joint foreign and mainland Chinese assets, evidence or conduct. So you see a rather crowded map there that will give you an indication of the number of cities to which applications have been made. And we're not just, again, looking at Beijing and Shanghai and Shenzhen. There are a number of different cities there, and the courts have been receiving those applications. Next slide, please. So the second part, the second instrument, is the arrangement on enforcement of awards. So looking at the end of the arbitral process here. This arrangement is not new. It was entered into in 2000. And effectively, it's a legal arrangement between Hong Kong and mainland China for the reciprocal enforcement of arbitral awards. We need that because Hong Kong is not a state in its own right, so it's not a signatory in its own right to the New York Convention. So when Hong Kong was handed back to China, there was a gap effectively because Hong Kong is a separate legal system, and so Hong Kong awards were foreign and vice versa. So an instrument was introduced for the effective recognition and enforcement of awards between the two. Terms similar to the New York Convention. It's been working well, actually, in practice. So Hong Kong mainland awards have been enforced in Hong Kong. That's not unusual. Hong Kong's a pro-arbitration jurisdiction. Very few awards don't get enforced. But importantly, Hong Kong and HKC awards have a good track record of enforcement in mainland China under the arrangement. Only 3 awards that we're aware of have not been enforced in the last 20 years. So it was working well, but there were some amendments made. Next slide. In November 2020, and really the main goal of the amendments were to bring it even closely in line to international practice and the terms of the New York Convention. And I think this says a lot as well about mainland China's increasing desire and commitment to practice international arbitration to international best standards. Both of these arrangements, I think, reflect that to a large degree, and Hong Kong obviously has an important role in supporting those developments. So just running through these amendments, the first one here, what we're looking at here is the original arrangement only referenced the term enforcement and didn't refer to recognition. And as we know, the New York Convention refers to both recognition and enforcement, recognition being the process of giving effect to and conferring binding status of the award, and enforcement, excuse me, the execution of the terms of the award. So with the use of just enforcement, there was some divergence in practice and interpretation by courts in mainland China. So by introducing recognition and enforcement, hopefully that will mean the application and that those terms are much more clear and closely aligned to the New York Convention language. The second one is amendment is in terms of the scope of application. So the arrangement applies to mainland and Hong Kong awards. Hong Kong awards are those made under the Hong Kong arbitration law. Previously, the mainland awards were only those rendered in proceedings by designated commercial Chinese arbitration commissions, so slightly narrower in scope. That's been amended so that the reference is to mainland Chinese awards made under PRC law. So it's broadened the scope there. Importantly, Amendment 3, simultaneous applications. Previously, the arrangement prohibited a party from seeking enforcement in Hong Kong and mainland China at the same time. That's been amended so that parties can now seek enforcement in both jurisdictions, but provided that the amount sought in each application or jointly does not exceed the amount awarded in the award. So that's just a practicality, so that it means that, you know, if you pursue proceedings in China, for example, and you can't pursue them in Hong Kong, perhaps there might be time limit issues if you're unsuccessful in one jurisdiction. The fourth and final supports the interim measures arrangement, really, but this amendment confirms that Hong Kong and PRC courts can issue interim measures during the enforcement process. So there you have, with the interim measures arrangement and the amendments to the arrangement on the enforcement of arbitral awards, you really have a complete support for preserving assets throughout the arbitration process. I appreciate that I've whizzed through those, but I never like to leave the person who follows me with less time than I have, and hopefully I haven't done that. But suffice to say, these are recent changes and important ones. The interim measures arrangement in particular is something that if you're advising deals and contracts that involve PRC parties, it really is something to keep in mind with respect to how effective, should a dispute arise, the process can be. If ultimately you have assets at the end of it, then that's a bonus. But I will leave it there, Claudia. Thank you very much.
Thank you, Kieran. That was in fact a very effective way of letting us understand these arrangements in a short period of time. So thank you so much. And I would like to just make a quick follow-up question before we move on to our next topic. And is it does the interim measures arrangement change anything for the way interim relief is sought in Hong Kong?
Oh, yes, it doesn't. Really, the difference is for the parties are able to seek interim relief on the mainland, but have their arbitration seated outside of the mainland, i.e. in Hong Kong. So as you might expect, if you know Hong Kong as a jurisdiction, but it's Untitled model law based, and the most recent version, and decades of arbitration work in this international city. And so we also have specialist arbitration judges. And so in terms what you would expect in an international setting, you get here. So parties can make applications directly, mainland parties can make applications directly to the Hong Kong courts for interim measures. The Hong Kong legislation recognizes, just moving a little bit away from that topic, but interim measures in terms of emergency arbitrator decisions. So there's nothing new for Hong Kong really under the arrangement. It's always recognized or issued interim relief in support of foreign arbitrations, including mainland China.
Thank you, Kieran. So now let's move on to the third topic that we have for today's agenda with Damaso. There was a recent Spanish Constitutional Court ruling, a very recent one issued in February 2021. And given its importance, Damaso is going to share with us the key aspects of this ruling. But before we go into the detail of the ruling, Damaso, what is the background? What happened before we actually or the Spanish Constitutional Court actually issued this ruling? What happened before that, to put our audience into context?
Thank you, Claudia. The background for the February ruling is the following. For the last 5 or 6 years, a number of cases were set aside, a number of awards were set aside by the Madrid High Court. And importantly, this is the state court in charge of most annulment actions in Spain, because most arbitrations in Spain are seated in Madrid. The basis for those judicial decisions to set aside awards was an increasingly broad understanding of public policy, which, as you know, is one of the gateways for annulment under arbitration acts based on the ancestral model law, like the Spanish Arbitration Act. This trend of judicial activism in the Madrid High Court started around 2015 with banking law cases following the 2008 financial crisis, which in a way bordered consumer law. They referred to contracts with sophisticated financial products entered into between banks and small companies, which ended up causing substantial losses to those companies. And that activism gradually moved towards other types of cases, as sometimes happens. You add a new tool to the lawyer's toolkit, and lawyers end up using it, in some cases successfully, for new and initially unforeseen purposes. And the Madrid High Court used 2 main techniques to set aside awards. A newly created notion of economic public policy, which would include basic contract law principles, and a broad understanding of the duty to motivate the award, also presented as a part of public policy. Both techniques, many of us thought, led to the High Court reviewing the merits of the case, with the excuse that basic contract law principles may have not been honored, or that the award may have been insufficiently motivated. And therefore, those techniques ran the risk of defeating arbitration's purpose, which is having arbitrators and not judges solve the dispute. All of this generated a concern, which was a bit exaggerated in my view, but still a concern that some people had about Madrid and Spain as a suitable seat. There is no evidence that arbitration cases dropped as a result of this judicial activism, but some sophisticated and very prudent parties indeed located the seat of their arbitrations in other cities in Spain, such as Barcelona, Bilbao, or Valencia, for example. Whatever the real effect of that judicial activism may have been in terms of trust by the users in arbitrations seated in Spain, the important point today is that it led to the annulment of a number of awards. And what happened then is that some of those annulment decisions by the Madrid High Court were then taken by the losing parties to the Spanish Constitutional Court on the following basis. Those judicial rulings which set aside awards had to be reversed because they run against the right to opt out from the state court system by submitting to arbitration. This flow of cases to the Constitutional Court has led to, for the time being, to two landmark decisions by the Constitutional Court. The first one was issued some months ago on 15 June 2020, and it already rejected a broad understanding of public policy. And the second one was issued 2 weeks ago on 15 February 2021, and this is the ruling we are specifically celebrating today. Nevertheless, if I may, I'll complete my answer to your first question on context with a few words at least about the previous June 2020 ruling, which is in a way a stepping stone for this one we're commenting. The conflict underlying the first ruling is a small dispute between a landlord and a tenant for unpaid rents, which was resolved in arbitration, and the award was subsequently set aside by the Madrid High Court. For you, those of you interested, the case is extensively commented by Elena Gutierrez in the ICC bulletin of November 2020. Nevertheless, I want to highlight 4 points of that stepping stone June 2020 ruling. First, the Constitutional Court recognizes that, as envisaged in the Spanish Arbitration Act, the annulment proceedings must be interpreted as an external control of the award and shall not include a review of the merits of the case. First, very important point. Second, the court also acknowledges that, quote, the ultimate purpose of the arbitration, which is no other than to reach an early extrajudicial solution to a conflict, would inevitably be distorted in the event that the arbitration decision could be subject to revision on the merits by the courts. So a strong endorsement for arbitration. Third point, the judgment also provides for a limited definition of public policy linked to fundamental rights and freedoms guaranteed in the Constitution, which is consistent with the international notion of public policy. And the Constitutional Court also alerts of the risk that the blurry limits of public policy could be used as, quote, a mere pretext by the courts to re-examine the issues debated in arbitration proceedings, distorting the arbitration institution and ultimately going against free will of the parties. Okay, so that's the background for our February 2021 ruling, which confirms and complements that robust statement by our Constitutional Court in favor of arbitration.
Thank you, Damaso. And then, of course, we want to hear more about the 15 February 2021 ruling. We want to get more details about it. But before we go there, I would like to ask you a very quick question. When you mentioned that the parties took this to the Constitutional Court, was there any allegation that by annulling the case on those grounds and the type of interpretation that was given by the High Court violated something called the fundamental right to arbitrate?
It's not expressed in that way, but the ultimate idea is exactly that. The idea is, okay, if the standard of review in annulment is too broad, you are effectively going against the right to opt out from access to justice in the sense of access to state court justice. So I don't think the exact words are as nicely put as you put them, but the idea is, yeah.
Great, thank you. So please tell us more about that 15 February 2021 ruling.
Okay, I'll give you a bit of information on the case first and then move to the implications of the ruling. This February 2021 ruling examines the Madrid High Court's decision to set aside an award decided ex equo et bono in a corporate case. And in that award, the sole arbitrator decided to liquidate a family-based company on the basis of abuse by the controlling shareholder. And the context for that alleged abuse was a long-standing conflict between the controlling and non-controlling family blocks. Set-aside proceedings against that award were brought by the controlling shareholder, the losing party in the arbitration, on the basis that the arbitrator's decision was insufficiently motivated and evidence was wrongly assessed by the arbitrator, both of which, according to the losing party, were part of public policy as a matter of Spanish arbitration law. So the Madrid High Court had to analyze the issue of motivation, and it did the following. It did a very strange thing. Until that ruling, there was what I would say a widely accepted consensus as to the motivation test in setting aside proceedings. Awards had to, at least that's what we thought, awards had to express the reasons that led to their decision, and that decision was subject to a rationality test, and that was all. The Madrid High Court, however, in this case, departed from that test when analyzing the case and set a much more demanding standard of review. In its ruling, it argued that the annulment tribunal had to check not only that awards had to express the reasons that led to their decision and the rationality of that decision, the Madrid court added another layer to its review and decided it also had to check something else. So what is this something else? The arbitrator's decision not to analyze certain pieces of evidence in the award, which the arbitrator considered non-decisive. So if in the eyes of the annulment court, according to this new decision, the arbitrator's conclusion is not sufficiently justified as to why it didn't analyze certain pieces of evidence, the award can be set aside. And this shifted the focus completely in terms of motivation, as I'm sure you're aware, because it made the test incredibly demanding. First, it forced arbitrators to potentially analyze all pieces of evidence and argument in the award and explain why each of them was or was not decisive. Well, anyone confronted with a construction case can very quickly conclude that this is simply impossible when you're faced with tons of documents. So first problem. Second problem, it made my life more difficult because we carry out scrutiny of awards at MAIAC and the Madrid Court of Arbitration. And this new doctrine arguably meant that we had to check not only the award when presented to scrutiny, but also all the file in case some piece of evidence had not been sufficiently analyzed and its importance sufficiently rejected by the arbitrator. So in that particular case analyzed by the Madrid High Court, even though the award expressed the reasons why it decided to liquidate the company, and there is no question about that decision passing the rationality test, so put another way, even though it is unquestioned that the award passed the traditional standard of review in terms of motivation, it did not pass this new, more demanding test, and therefore was set aside. Why exactly did the award not pass this new, more demanding test? Because the award does not consider a number of pieces of evidence and argument, which, according to Madrid Court, run against its conclusion that the controlling shareholder abused its position. So what the Madrid Court did is it went through the file, it decided that a number of reasons might have led to the contrary conclusion. Those reasons were not analyzed in the award, and that meant the award had to be set aside. In very short words, the Madrid High Court analyzed the merits of the dispute and decided that the award reached the wrong conclusion. The party that had won the arbitration, the non-controlling shareholder, and then seen that award set aside, went to the Constitutional Court on the basis, and this goes back to your question, Claudia, that the Madrid High Court's decision to set aside was absolutely misguided to the extent that it unreasonably went too far when reviewing the award for lack of motivation, all of which damaged their constitutional rights. And the Constitutional Court agreed with the statement and annulled the ruling by the Madrid Court, which had set aside the award. This second Constitutional Court ruling in less than a year is very important for a number of reasons, which I'm sure have already become apparent. First, it confirms the previous June 2020 ruling in the sense that public policy in Spain is limited and cannot be used as a mere pretext to re-examine issues debated in the arbitration by the courts, distorting the arbitration and going against free will of the parties. Second, the ruling is important because it restores the statu quo ante apropos the standard of review of annulment courts when they analyze the motivation of awards. That is, it confirms that the shift towards a more demanding motivation test operated by the Madrid High Court is wrong. The correct test is the following, as it has always been. Awards have to express the reasons that lead to their decision, and that decision needs to be rational. Put another way, awards will be annulled only if they evidently rely on non-existent or patently wrong premises, or the reasoning includes logical mistakes. Third, as a consequence, awards need not analyze all evidence or argument presented by the parties. Only those pieces which are relevant for the conclusion need to be analyzed. And finally, fourth point, a conceptual point, which is where all the problems began, as is normally the case. Arbitration, as clarified by the Constitutional Court, derives from the constitutional right to freedom, not from the constitutional right to access to justice. And this is very important because most of the positions taken by the Madrid High Court seem to stem from the mistaken understanding that arbitration is an equivalent to court justice, which it is not as a matter of Spanish law. The correct understanding, of course, being that arbitration is only an equivalent to state justice in the sense that awards as state court rulings have res judicata effect and put an end to the dispute. But the origin is freedom, not access to justice. And that is why the standard of review that you would apply to a judicial resolution does not apply to an arbitral award. So all of this has finally put an end to a trend in the Madrid High Court, which created concern as to the suitability of Madrid and Spain as reliable seats. And we're particularly happy to see this coinciding with the launching of MAIAC, which is aimed at promoting Madrid and Spain as a hub for international arbitration, particularly for obvious reasons, but not only in disputes concerning Latin America. So in a very short heading, we are very happy. Thank you very much.
Thank you, Damaso. And I would love to make so many questions because this is just such an interesting topic and relevant not only to Spain, but to many other countries, in countries like Colombia, for instance, where we also have a constitutional court, and our constitutional court has a say with what happens, let's say, at annulment courts and the annulment decisions and how to interpret at the end of the day the arbitration law. All this is very relevant. So thank you so much for that. I guess that we'll have the opportunity to further discuss this topic because for the time being, time is over. So thank you so much. This has been so engaging and the topics have been so relevant to everyone. I'm absolutely sure. Very much appreciated. Thank you for this very interesting intervention.
Thank you.
Thank you.
Thank you, and thank you everybody for attending. And I'm sure, very sure, Damaso, that we'll be organising many more of these. This was just a teaser, really, but we'll be. There's so many crossover points and points of interest for our different groups that we work with frequently. So we look forward certainly to working with MAIAC again. And thank you, Omar and Claudia. It's a pleasure, as it always is, and look forward to more virtual and hopefully in-person gatherings as soon as we're able to. But thank you all for attending and look forward to future events.